Ladies and gentlemen of the jury, you have been selected and sworn as the jury, in this case to try the issue presented by the indictment and the defendant's plea of not guilty. Your duty is to determine whether the defendant is guilty or not guilty in accordance with the law and the evidence presented. It is the law of this state that the indictment is not evidence of guilt. The defendant has entered a plea of not guilty. This plea puts in issue every element of the crime charged. The defendant is presumed innocent, unless the state proves the defendant's guilt beyond a reasonable doubt. To prove the crime of grand theft, the state must prove the following two elements beyond a reasonable doubt. John Doe knowingly and unlawfully obtained or used, or endeavored to obtain or use, the property of another. He did so with intent to, either temporarily or permanently, deprive the other person of a right to the property or any benefit from it, or appropriate the property to his own use, or to the use of any person not entitled to it. The defendant's intent is a question for you to determine. You should consider the nature of the acts and the circumstances surrounding them. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement that any fact be proved by more than one witness. You should consider all the evidence in light of your own observations and experiences in life. In our system of justice, the jury is the judge of the credibility of the witnesses. You are free to believe, disbelieve, or partially believe any witness. In evaluating the credibility of any witness and the weight you give to the testimony of any witness, you may properly consider the demeanor of the witness while testifying, the frankness or lack of it, the intelligence of the witness, any interest the witness may have in the outcome of the case, the means and opportunity the witness had to know the facts about which the witness testified, the ability of the witness to remember the facts about which the witness testified, and the reasonableness of the testimony of the witness, considered in the light of all the evidence in the case and in the light of your own experience and common sense. The law does not require the defendant to prove innocence or produce any evidence at all. The burden is on the state to prove the defendant's guilt by the evidence. The state must prove the guilt of the defendant by evidence to the exclusion of and beyond a reasonable doubt. If the state fails to meet this burden, the jury must find the defendant not guilty. Evidence may be direct or circumstantial. Direct evidence is the testimony of one who asserts actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of a fact. The law makes no distinction between the weight you may give to either direct or circumstantial evidence. However, a conviction based on circumstantial evidence alone is not to be sustained unless the evidence is consistent with the hypothesis of guilt and inconsistent with any other reasonable hypothesis. It is not sufficient that the evidence creates a strong suspicion of guilt or even a probability of guilt. In considering the evidence, you should consider the possibility that although the evidence may be consistent with the hypothesis of guilt, it is also consistent with the hypothesis of innocence. In this case, you have heard testimony from various witnesses, and you have been presented with physical evidence. It is your duty to determine what evidence is credible and decide what weight should be given to that evidence. While you are permitted to draw reasonable inferences from the evidence, you must not speculate or guess about any matter. Your verdict must be based on evidence and on that alone. The law requires that you return a unanimous verdict. This means that to return a verdict, each of you must agree to it. Your verdict must be the result of serious consideration and not a decision reached by chance. Your sole interest is to seek the truth from the evidence in the case. A verdict in a criminal case must be unanimous. All of you must agree whether the defendant is guilty or not guilty. You should discuss the case with one another and deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of evidence solely because of the opinion of your fellow jurors, or for the mere purpose of returning a verdict. Remember, if there is a reasonable doubt as to the defendant's guilt, that doubt should be resolved in favor of the defendant. If, after fair and impartial consideration of all the evidence, you are convinced beyond a reasonable doubt that the defendant is guilty, it is your duty to find him guilty.